Welcome to another episode of Top Real Estate Secrets. I'm your host, Liz Boyce, and today we have a very important person who I think is one of the most important people to have on your team. It's attorney Atty DeSanti.
Hey, Liz. Thank you so much for having me. Again, I'm Atty DeSanti. I'm the owner and attorney for the legal planning firm. Been practicing in the state of Florida for over 8 years, helping buyers and sellers in the real estate industry get to the closing table.
Right. Yes. I think that when you have a great team and you are going to sell your home by yourself, that it's important to have the best people that you have out there. And Erica is, one of those. Tell me a little bit about your companies that you have.
All right. So my law firm really just takes that hands-on and practical approach when it comes to planning for you, your family, and your next move. A lot of times that move is to sell your property. The great thing about us is we offer a flat fee for our sellers, and we can start that process right in the beginning, right when you decide that you want to sell. That advice, that guidance, that education, that starts right then and there. You don't need to wait to have a buyer. You don't need to wait to have a contract. We want to be a part of that entire process. And that's really what the legal planning firm is all about. Let's plan, let's make a plan, and let's implement all of those tools that we have to get our goals accomplished.
Yes, I completely agree with you. How do you feel about people that want to sell their home on their own and without a realtor?
Well, it can be a great thing as long as you have the right team. You need to get those tools in place. It's more than just being ready and able to market that property and find your buyer. It's about what happens once you find that buyer. And that's where the legal planning firm comes into play. We assist in contract preparation, review of any contract that a buyer might bring you, so that you can make sure that all the terms that you think that you're ready to agree to are being able to be implemented into a contract form and, most importantly, legally effective.
Right. Yes. And a lot of people, speaking of legal, they think it's illegal to sell their home on their own. What would you say to people that are skeptical about that?
Well, in the state of Florida, it is not illegal to sell your home on your own. You can certainly do it. It happens all the time. And it's just one of those things that it can just get a little bit sticky. Of course, if you make contracts, get into agreements that you don't understand.
Yes, yes. And so typically as the selling agent or the seller, when you get a contract, the buyer's agents are the ones that actually write the contract for us to kind of keep us fair in the game is what we call it. So we'll be looking over the contract, which is where you come in, and using you as a title company. That's one of your services that you do offer when you use you as a title company.
So a lot of times when you're doing for sale by owner, the buyer may or may not have a realtor. So when the seller and buyer come up with a plan, they kind of don't know where to go from there. So typically when I'm dealing with for sale by owners, I'm the one to always prepare the contract to get it ready. And then we always suggest that the buyer circle up with their own attorney to go ahead and get that reviewed.
Yes, or their agent. And I always make sure that I tell for sale by owners that it's important to actually still work with a buyer's agent. Even though you're saving money on the commission side for a listing agent, the buyer's agents are the ones that bring the buyers. So make sure that you pay them because you want them to be there in your house, bringing all those people through, from there. So.
Yeah, we're seeing that more and more.
Yes, very true. Let's go over the contract a little bit. I know that is one thing that a lot of people struggle with. They get nervous about it, but it's we are licensed here in Florida. We work with attorneys throughout the United States and also other title companies that can actually help you do the same process that Erica can look over too. But here in Florida, we're going to go over a little bit of the contracts and the steps that it takes. It is different in the state and other states, but like I said, we work as referrals with other, agents and also title companies and attorneys. But here in Florida, once you accept an offer, let's see, the next step is going to be escrow. So can you just kind of walk us through on what the escrow is, who accepts the escrow, and what kind of problems there can be with an escrow?
Absolutely. So what there's going to be is some language in the contract that the buyer and seller come to an agreement on, and that's the deposit. So you agree on a purchase price, and then you agree on what the good faith deposit's going to be that the buyer is going to place in escrow, which is a bank account essentially that's held by your title company and escrow agent, where that money is kept safe and held and only to be dispersed according to the terms of the contract. So the terms of the contract state that that money should be applied towards the closing costs, the purchase price. If the buyer defaults, there might be a clause in your contract that says that escrow money is to be distributed to the seller. There might be a clause in there that says you have an inspection period for a couple of days, and if the buyer decides that they don't want the property during that inspection period, then they get to go ahead and take that money back and put it back into their pocket. So the contract's really going to dictate what happens with that escrow deposit and how much that escrow deposit's going to be.
Yes, I love that. And I also, just doing this for so long, there's different ways that you can drop escrow, which is in 3 days. The buyer needs to drop the money into the title company or wherever it's being held. And then also, if you want to make your contract stronger, you can also drop another escrow after the inspection period. That way it says, hey, I'm really serious about buying your house. I'm going to give you a little bit now and then a little bit later as well.
Yeah, we love that, especially because we'll set that up after the due diligence period's expired. So after the buyers realize, yes, I'm definitely going to buy this property, all the contingencies are done, let me go ahead and double down on my initial deposit to really show you that I'm ready to roll.
Yes. I always get this question, and that the sellers think that because someone puts $10,000 in escrow, that they're immediately going to get that money as soon as something happens. But I have to explain to them, hey, that money is not available until basically, I always say that money is not vulnerable until the loan commitment period, because after the loan commitment, that's where it starts to get, okay, now are you approved for your loan? What's going on? Because you've already passed the inspection period. Now you're going to, the next up is the loan commitment period. And it's not even really vulnerable then, because if the buyer is denied the loan, they still get that money back.
Absolutely. So that would be just another contingency within the contract that speaks to what happens with an escrow deposit. If a buyer is coming in and they're not an all cash buyer, they're a lender transaction, there's going to be a contingency in there that says that they have, for example, 30 days from the time we enter into contract to get approved for a loan. And in the event they don't get approved for a loan, then they have the right to have their deposit released back to them. That's definitely something that buyers always want to see in there when they have a lender transaction as a protection for them. And yes, it might be a little bit uncomfortable for a seller to think like, wow, I'm, putting this money, I'm putting my contract, I'm taking my property off the market for 30 days and it might just have to go back on the market and I have nothing to show for it, which kind of leads into the next conversation that we might want to have. And that's just like doing your due diligence on your buyer, taking the time to say, okay, do you have loan approval? How far are you along in the loan process? Do you have, any sort of approval letters from your lender? What type of employment do you have? So you can really see, does it make sense? Is it logical to think that this buyer is going to actually qualify for this loan?
As soon as I get a contract, and let's say I have 3 in front of me, I call each one of their lenders and ask those exact questions. And I say, hey, did you run them under the desktop approval already? Because if they say yes, then I know they've accepted their pay stubs, they've looked at their taxes, and they looked and they ran it in the system, and they know that, hey, they can buy a house. And I will, if one contract has not done that, then I will accept another contract that has already done that, because it's a good due diligence, like you said.
Absolutely. If a buyer's coming to you and they don't even know who their lender is going to be yet they're looking to get a 90% loan, that's a huge red flag. That's something that you say, okay, let's pump the brakes, Do you have a lender? Why don't you circle up with one? Let's get that process rolling. Let them run your credit. Let's get some pre-approvals. And guess what? Lenders are fabulous when it comes to that. They'll get that done within 48 hours. So it's not something that's going to totally, slow down your deal. And sometimes just taking those extra couple days can save you from taking 30 days with your property off the market and then getting your feelings hurt when the buyer doesn't qualify. And then you have to hand them back the deposit. And you just missed out on a bunch of buyers that could have come your way within those 30 days that maybe were qualified.
I agree 1000%. So after we pass the escrow, next up is going to be in the inspection period. Love that. And tell me some things that you have come across during the inspection period that have been detrimental to a seller.
So if you're a for sale by owner, it doesn't hurt to maybe get your own inspection done or take a look at an inspection that you've had done recently when you were updating your insurance or something. Take a look and see where the weaknesses lie in the property, being kind of upfront with your buyer right off the bat. They're going to get an inspection of the property. They're going to take a look at everything that's going on, the roof, the plumbing. So it's really important to just be upfront. Hey, yeah, the roof's 10 years old. It has a couple of leaks. The price that I'm agreeing to is based off of those known facts. So I'm accepting this purchase price for you, already knowing that these things are going to need to be fixed. This kind of saves a lot of back and forth because a lot of times we see buyers come back with an inspection report. And if the property isn't perfect, they're going to try to then nickel and dime you and bring you down in price. And we're just back to that negotiation, back to the drawing board. If you kind of tell them, listen, the purchase price that I'm agreeing to you right now is based off the fact that we do have some issues with the property. And those are things that, you will need to probably repair or live with or deal with or know that might need some tender love and care down the line. So it's all about just being upfront with what you know about your property, disclosing that to the buyer right off the bat. So then when they come back and they say, oh, it looks like there was like 3 repairs done with the roof and it might need a new roof in 3 years, you're like, okay, well, you already knew that. So then you agree to the purchase price based off of that. These are things that, Liz and I can always assist you with when it comes to that negotiation process. And when we're agreeing to the purchase price right off the bat, just kind of disclosing all of those different, I don't want to say issues, but, just the status of the property, all the different pending repairs and things of that nature.
Yes. In fact, in one of my other episodes, I talk about how you should do the inspection. I try to cure everything before we even hit the market. Let the other side know, hey, listen, I have this going on, but I'm not going to repair it. And the home is sold as is, and this is what it is.
Another thing that you should always take a look at, do you have any pending city matters, any open notice of commencements? Have you gotten some work done on the property? Have your contractors terminated those? Are all the permits closed out? That's another great thing to take a look at. And we can certainly, do lien search reports ahead of time and things of that nature. So we can just make sure that all of those matters are cleared up, which are really important matters when it comes to dealing with a buyer that has a lender, because those are going to be required to be cleared prior to closing, whether it's the seller's responsibility or the buyer's responsibility. So we need to know if those items exist so we can discuss them ahead of time and negotiate accordingly.
Speaking of that story, I had a client and they got about $120,000 worth of windows in their property, but they had a balance on there. And when we went to go sell their property, we went under contract. The title came back and said, hey, you have this open permit. And I spoke to the client and they said, hey, we're really unhappy with this window company and we don't want to pay them. And so I immediately had to call Erica and I said, hey, listen, they don't want to pay. What can we do? How can we get through this and kind of work everything out? And basically, we had to sign some paperwork that said the buyer wasn't responsible for the windows, but the seller was, and we were able to kind of get it closed and go from there.
Absolutely. And again, all of those things, knowing ahead of time makes things a lot easier because we can kind of just sort it all out before us as sellers are locked into a contract. Now, all of a sudden, we're required to cure that matter. All of a sudden, we have to pay $100,000 violation that we didn't plan on paying. Our bottom line just changed. Now we're bringing cash to close. You need to really think about what is affecting your property or know what's affecting your property prior to entering into a contract, because that purchase price might not make sense based off of the, encumbrances that you might have on the property that you might not even realize are there.
No, I can't tell you how many times I've gotten a title commitment back, and then it says open permits, open expire permits. And a lot of people stress out about it, but it's really not that hard. If you have a good team or a good realtor or yourself, you could just go on the property appraiser website, look at it, contact the building code, and then go ahead and send them an email and say, hey, I have this expired permit. And a lot of times they just wipe it clean because it's so old.
Absolutely. And the only thing that, we want to be careful of if we're already in contract and then we're finding out about this on the back end is that might mess with our timeline. That's going to mess up the buyer getting into the property on the closing date. Their loan approval is going to expire. It can really mess up a lot of things because those things do need to be cured prior to the closing date. So if we have a quick close of 30 days and we don't find out until 15 days in that we have these pending matters, and it takes 10 business days to get the city to clear them out, which they have no problem doing, but there is a process to it. That can kind of blow up the entire deal and create a lot of havoc. So again, it's just kind of planning, and knowing all the things to expect.
Which brings me back to why I work with the title companies that I work with, because being a buyer's agent as well, I can tell you that sometimes the seller has chosen a really bad title company and I have to wait for them to get me that title commitment. And sometimes they don't do it until like 8 or 10 days before. And then you find all this stuff and I'm freaking out. But the reason why I work with Erica, the reason why I work with Fidelity National are because immediately when we go under contract, they're already getting started. They're doing their job and they're getting it out within sometimes just a week.
Absolutely. So yeah, there are some companies out there that don't order things until after the due diligence period has expired. We have agreements with all of our vendors that we are able to order these things right off the bat. We don't care that, it's incurring expenses and things of that nature. We're able to get those wiped out and handled on our end if for some reason the deal falls through. So that's why some companies, err on the side of caution. They don't want to be at a loss if the deal falls through. So until it really gets finalized, they want to kind of not order things. But that's not how our company works. We order as soon as we get a contract. It's going to be within one business day that the title order is going in, lien search orders going in, so we can be ready to roll and understand what's going on with the property ahead of time.
I do. I love that about you guys. Next up, let's talk about the closing date. A lot of people, want to know, well, when is my property going to close? What date should I accept? How does that work? And so one of the things that I want to talk about is that when you accept a contract, it is important to say on or before this date. So that way, as the listing agent or, as you helping out with the addendums, you don't have to go back and say, okay, let me do another addendum for the closing date, which just makes that go into underwriting for the buyer's agent again. And it just kind of does that. So on the closing or on the contract, when you see the closing date, let's just make sure that it says on or before this date, because you can always extend it. But it just is kind of helpful.
Yeah. So that on or before language, what it means is it has to close by that date that's listed there. Okay. That's the date that everyone has to close by. So if somebody wants to close sooner, but someone else doesn't, so you as the seller, you definitely aren't sure if you want to close before the date that you're providing because you need to move out, you need to secure your next property. Don't be scared to put on or before though, okay? Because by putting on or before, it doesn't mean you have to close before. You only have to close on the date that it has to be by, okay? So that date that's listed is the date. So if you find that the buyer comes to you and says, oh, I'm ready to go, and that's 5 days before what you've listed on the on or before contract date, you could say, well, listen, I'm not. So unfortunately, we're gonna have to stick to that date. However, this is a great thing for sellers that say, okay, I wanted to close as soon as possible, but it's really the buyer that needs that longer time because, they're dealing with loans and financing and things of that nature. So then all of a sudden, their loan officer shines bright and says, hey, you know what? We got this loan approved a lot sooner than we thought, and we can close a week sooner. Seller, are you ready to roll? And seller says, yeah, absolutely. I want to get this thing closed as soon as possible. So you go ahead and you just go ahead and move on with the contract rather than having to draw an updated addendum stating that new closing date. So this is a great way to just kind of add some flexibility to the closing date without tying your hands to a closing date that's earlier than what you're kind of anticipating. I love that language when it comes to the on or before. And everyone just needs to remember that date that you have as your closing date. You need to be careful with what you're choosing. I know we want to close in 2 weeks. I know you want to close as soon as possible. But remember, things can come up in title. Things can come up with you trying to move out. Things can come up with you trying to get your next property. Give yourself that time. 15 days extra than what you've anticipated, right? 30 days, I think, is always the magic number. 45 if it's a loan transaction. You don't want to kind of cut yourself short on the dates and then have to create new negotiations or put yourself in a position where you're not ready when you have to be. So now all of a sudden you're paying for an extension, and that's not where you want to be. Couple things to keep in mind when you're dealing with the closing date and selecting a closing date. Does the buyer need to get condo approval? Does the buyer need to get HOA approval? Do you have any pending title issues or permitting issues or things of that nature that you're going to need to get cleared up? Is it a lender transaction? Is this property going to be a property that you want to move straight from this property to the next property? Is that property that you're moving into going to be ready? These are all the things that we're going to customize our approach for you when it comes to thinking about that closing date. So we want to make sure that closing date not only works for you, the seller, we want it to work for the buyer too. We need this date to work for everybody. So all hearts are beating as one and we are having a nice, smooth transaction.
When you work with us and depending on what package you choose, we have a full service package where we just do it all. And then we have the middle package where we will actually help you write the addendums, negotiate it, and go from there. Or we have the package where you could just do it on your own and we'll get you in your local MLS and kind of go from there. But I highly suggest that you use the middle package at least, because that way you have access to us. And, it could be on an addendum as little as, hey, you have to say it exactly like this. The seller gives a credit to the buyer of $10,000 towards closing costs. You have to be very specific on how that's written, because if you give it to the underwriting on the other side, they may reject it and not like it. Or if you even have it on an addendum that we will fix the leak in the master bathroom. There could be no leaks in the property. A lender will not approve a loan on certain things like a leak. And so that's where Erica and I come in. We help you with things and, go from there.
I always tell my clients, tell me what you want. Tell me what your goals are. Tell me what you're trying to achieve here. Don't try to write it down. Don't try to figure out how I'm going to do it. Just tell me what your end game is, what you want. At the end of the day, the buyer says, when I come in, I want that bathroom to be perfect. I want it to be in perfect repair. Okay. And then we'll take it from there. We'll figure it out. And then also when we're talking about these addendums and things of that nature that we're trying to put into place, sometimes we don't realize that $10,000 credit can't happen because the buyer has to bring a certain amount of cash to close based off of their loan terms. So we're thinking about 10 different things and how this is going to affect your deal from a holistic approach. Sometimes it's just not as simple as, I'm the seller, I agree to give you a $10,000 credit, and then the buyer's like, awesome, and that it's going to happen. Because remember, there's more than two people in this transaction when you're dealing with a buyer that is getting a loan. We're dealing with a borrower, we're dealing with a lender, and we need to make sure that we're navigating our transaction in consideration of that loan being approved.
Yes, very true. How do you feel? So I actually met Erica a couple years ago off of a post-occupancy agreement, and also just a regular contract. But I had to do a post-occupancy, and my client said, "Hey, I'm working with this lawyer. Let's talk to her about it." And she taught me a ton because I was doing just the regular from the title company, from my broker, 1-page post-occupancy. And then I spoke to Erica about it. And now she has like a 3-page post-occupancy that covers everything and protects the seller or the buyer, depending on which side you're on. And so tell us, how do you feel about a post-occupancy? Because I do try to stay away from it. But sometimes that the people, they need that lease back, and it can be very sticky. You don't want people to get you can get to an evictions. What happens if they decide to not leave?
Yeah, exactly. So that kind of goes back to my point. Sometimes you think that you're just making a simple agreement between two parties, like, hey, no, I don't need to be in the property until a week after we close. So if you want to stay for an extra week, no big deal. Like, fine. And you guys agree to it, and it's all well and good. And you write a simple little addendum saying buyer agrees to allow seller to stay in the property for a week after closing. All right. Well, there's a lot of other things that come into play with that. Who's going to cover the expenses for the property for that week? Who has, now all of a sudden, you're a buyer, you own that property, you have a person staying in your house. Yeah, it's not a random person, it's a person that owned the property, but liabilities, who's taking on certain liabilities for things that might occur on that property? There's so many things that fall into play when it comes to post-occupancy agreements. Quite frankly, you really need to treat that seller like a tenant. You need to set up a post-occupancy agreement that's almost similar to that of a lease. What happens if they don't get out in a week? What happens if all of a sudden they don't get out in a week? And now you have somebody holding over in your property. Now you have to go through eviction processes. This is why we want to make sure that there's things in there that incentivize your seller to get you as the seller to get out of the property. A per diem amount that they'd have to pay per day if they hold over the week. A deposit that's held in escrow to actually cover that amount. Okay, so there's a lot of things that we're looking at here. When I'm representing the seller, of course, I'm confident that the seller understands what's going on. I'm going to explain that to them, and my loyalty is lied to the seller, so I'm going to always push for the post occupancy, and I'm going to, of course, negotiate with the buyer and incentivize the buyer to agree to it by adding some sort of finance or some sort of amount that we would pay them in exchange for that, creating a document that knowing, listen, you are going to be covered. They're getting out in a week. And if they don't, guess what? You're going to be better off for it. You're going to make a bunch of money if they don't get out.
Right.
And this is kind of how we navigate through that. If there's repairs that need to be done, the property isn't what it was at the time of closing. And all of a sudden, when the seller moved out, they damaged a bunch of things, and all of a sudden it's not what it used to be. So there's also security deposits that get held back.
Yeah.
We're going to make sure we're kind of looking at both sides in order to get that deal negotiated. So again, smooth transaction. Everybody's happy. We want everybody to be happy. This isn't kind of like your mediation situation where I don't know if it's kind of common in the legal world. A mediation, everybody leaves pissed off and you know that you got a good deal, right? But in a closing, we want everyone to leave happy. And that's how you know that you negotiated well and you thought of everybody and everything.
Yeah.
I will say pre-occupancy, I'm not into it. We're talking to sellers right now. You guys are thinking about selling your property. You want to get the buyer in because they're, oh my goodness, I need to get into this property right now, but my loan doesn't get approved for another 3 weeks, but I'm getting kicked out of the property that I'm in. Please, 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 please. I do not recommend a pre-occupancy. So a pre-occupancy is when you allow your buyer to come and live in the property basically as a tenant prior to them purchasing the property. I just don't ever see those things going well. Now all of a sudden they're in the property, they're picking everything. They might even say, "Listen, I'm just willing to let my deposit go because I don't like how the feng shui is and all of that." It's kind of like you're letting them go into your property, and it's worse than a due diligence. It's worse than a loan contingency. You're now letting somebody like try it before they buy it, and I don't think that that's ever really a good idea.
So I actually had a situation like that. It's funny. I had a home. It was vacant. We had a little bit of problems from the very beginning that I had to cure. Like the master bathroom was inside of the bedroom and there was no door, no anything. So the shower, the toilet, everything was inside of the master bedroom. And so, funny enough, it had been on the market for a while because of this situation. And I had these other buyers that were living in a hotel and they were desperate to find a home. And I said, they wanted to live in that area. And I said, "Hey, listen, I'm already a flipper. I'm a rehabber. Let me see if the sellers will allow you to go ahead and move in the home. I'll help you, hold your hand, we'll flip it and everything." Well, it was only about 8 days that they were going to stay in there and we allowed it to happen. But oh my gosh, they picked that place apart. And I said, "Don't worry, we can fix it." But I was actually got a little nervous because I thought, oh, what if they could walk away and not want to buy it anymore because they found these little things. And so from then on forward, I said I would never do that again.
Yeah, a lot of unneeded drama that you don't need as a seller.
Yes.
I'd give them a credit. I'd pay for them to live in a hotel before I'd let them in my
will
home.
definitely do that from the future, but that's why experience. You can't teach experience. So
that's where we come in, right? We really want to let you guys know, yes, are you equipped to find your buyer? Yeah, you kind of maybe even know who they are, but when it comes to just kind of getting all of those little fine-tuned details and these little things that come up, we've seen it before. We see how it plays out. Like I say, this is not my first rodeo when it comes to most of the things that we're doing. And at the end of the day, you make your own decisions. You're the negotiator, you're the business person, you're the owner. But I just want to let you know how this could potentially play out. And I also want to build in language to these agreements that you're making with your buyers to make sure that you are protected and that we're kind of covering this and how it would play out if it didn't work.
We together had a client, we had two clients that kind of I thought were very big problems and I had no idea how to handle it. But we went under contract for her to sell her house. She went through the inspection period. They didn't even ask for anything during the inspection period because her home was very nice. But then she started getting closer to the closing date and all of a sudden she turned cold feet and she's like, "I don't want to sell my house. I don't want to do this." And I said, "Hey, you're going to get sued because you have to sell your house at this point. A seller can't walk away. A buyer can walk away, but a seller, I called you and I said, what do I do?"
It's very unusual for a buyer to agree to enter into a contract with a seller that doesn't have a default clause that's called specific performance. So what happens if the buyer walks away? The seller walks away with their deposit, right? But if the seller walks away, you don't get to just give the buyer back their deposit and go about your life. There's typically going to be a clause within the contract that says that the buyer has the right to enforce specific performance. What that means is they have the right to go through the court system and sue you to get an order forcing you to sell their property to them at the terms that you've agreed to. So you got to be really, really careful as the seller signing up this contract. The buyer can sign the contract. They typically have a due diligence period, an inspection period, 5 days, 10 days, 15 days that they can decide to back out. They get to keep their deposit, or worst case scenario, that's the only thing that they need to let you keep is the deposit. But the seller, you literally are going to lose your house if you enter into a contract for something that you've decided that you don't want to do anymore.
Yeah.
So I always want to talk to my sellers. What's the plan? Where are you going next? Where are your, going to, how are you going to get everything moved out? How are you going to get to the next place? Again, like where you're going, what are the terms of that agreement, right? So sometimes we want to build in contingencies within our contracts that say this deal is contingent upon my purchase or my lease going through on the property that I plan on moving from. That's if, this is your primary residence and you're moving out. If it's obviously a rental, that's another thing. Now you're, potentially maybe having to kick out your tenant in order to get the person to come in. You don't want to be left without your tenant and then the deal fall through. There's a lot of things you want to consider, and it's all highly customizable. It depends on your situation as a seller. Is this an investment property? Is it a primary residence? What's the plan if it is a primary residence? Where are you going to go next?
Yes. Speaking of investors and investment properties, there's a clause in the contract that says assignability. I do work with a lot of investors, but when I'm working with just a regular traditional sale and it says assignable contract, I always make sure it says may not be assigned. How do you feel about that? Because I know you're in Miami. We do a lot of it down there, where you can assign it, you do a double close. Explain assignability and then explain why it's good and why it's not bad.
Okay, so when you're dealing with a lender transaction, right, your buyer is getting a loan to buy this property. We typically want to say that this contract's not assignable, right? Because at the end of the day, the person that is going to move forward with the loan application, that's going to move forward with the condo approval, that's going to move forward with the HOA approval. We need that to be that person right off the bat, right? If they now assign it to somebody else, now we're dealing with a new person that we haven't vetted. We don't know who they are. We don't know if they're going to qualify for the loan or not, that this whole contract is contingent upon. We don't know if they're going to get approved by the condo association or the HOA. It's very important that we know who our buyer is from day one when we're dealing with a lender transaction. I'm a lot more flexible when it comes to cash transactions because at the end of the day, as the seller, as long as you put up that deposit money that I'm asking you to put up and you want to assign the contract to somebody else and you end up defaulting and everything, I'm still taking my deposit money one way or the other, whether I'm taking it from you or the person you assigned it to, however you guys work that out. It's not as important to me. What I do like though is a little teeny bitty clause in there. If we are going to have it assignable, it has to be assigned within a certain period of time prior to closing. Why? Because I'm your attorney and I'm preparing all of your transfer documents, right? And those transfer documents include the name of the buyer. We're going to sign them up. We're going to get you all done ahead of time so you don't need to be stressing day of closing. And then all of a sudden they come and they say, oh, we've assigned the contract after we've done all of our work to, prepare all of our documents. So I kind of like to know like 5 days ahead of time. So if they want to assign it, it's fine. But you just need to let us know prior to closing.
Yes, I love that. Couple more questions and then we'll wrap it up. What happens if a buyer walks through a home and it is not the same as when they purchased it? What would a seller do? What would a buyer do? How do you handle that?
All right. So if we're entering into the typical as is FAR bar contract here in Florida, there's language in there that says that the property needs to be in the same condition that it was in at the time of entering into the contract. So let me give you a really simple example. At the time you enter in the contract, the stove doesn't work. And then they go and they walk through the property day of closing and the stove doesn't work. The seller does not have to fix the stove. It didn't work when you entered into contract, still doesn't work now. It's not the seller's responsibility. The buyer agreed to accept the property as is in the condition that it was in at the time of signing the contract. Let me kind of just build off of that same hypothetical. The stove works, okay? We enter into contract, the stove works. The buyer walks through, the stove works. Now the buyer walks through day of closing. The stove isn't working. Yes, it is an as-is contract, but again, you as the seller are obligated to keep it in the same condition that it was in at the time of entering into the contract. So who has to fix the stove? The seller. You need to make sure that that stove's working, or you replace that stove with a stove of like kind. Or sometimes you negotiate a credit. The buyer was going to replace the stove anyway, but it's a technicality and, they feel that it should be working. So we negotiate, a couple $100, for it.
Yes. So I'm actually listing one this week. She says, I want to keep all of my fans and I want to keep 3 chandeliers and I'm keeping my refrigerator. And I said, oh, okay, that's fine. That's totally fine. But we will not hit the market until I've gotten my contractor in there. He's removed the fans. He's put new fans up, and then we take the refrigerator, put it in the garage, and then we put a new one in there. Because I'm not going to take pictures and then have a buyer look at all these pictures and say, but the chandelier was in there. I want that. And it's just causing so many problems. So
right. And obviously, if you as a seller want to make sure that certain items are in the contract, are going to leave the property with you, there is a part of the contract that sets forth personal property within the property. So things that are included in the property, if you don't state otherwise, are going to be things like your refrigerator, fixtures, things of that nature. So if there are certain things that you want to keep, you need to make sure that those items are placed in special clauses within the contract. I would also attach pictures, and we know exactly which fan it is. We know exactly which refrigerator it is. Here's a fun fact. And Liz, I don't know if you know about this, but maybe you do. Washer and dryer. That list that I'm talking about that's in the contract, and they talk about the fridge and this and that, washer and dryer is not included. So if you as the seller want to take your washer and dryer, you can, because it's not included in there. We always add that in. We add washer and dryer in because the buyer assumes that they're getting the washer and dryer. That's the biggest one that I see the dispute. The buyer thinks they're getting the washer and dryer. The seller doesn't think that they're getting the washer and dryer. So that's something we always want to ask the question. And I always ask that question: is the washer and dryer included? Yes or no? And if it is, great. If it isn't, then we just want to actually further state it. So even though it's not listed on that list, we always want to be transparent. We want the buyer to know, like, yeah, I know you see a washer and dryer here. You might have missed it in the contract, especially when we're not dealing with realtors and things of that nature. We're all, doing for sale by owner here and might not have representation. We want to say, hey, like, that the washer and dryer isn't included. We're going to make a special little clause. Buyer acknowledges that the washer and dryer is not included in the sale. Doesn't have to be in there, but it's nice to put it in there so it doesn't come up as a dispute later on that you made some sort of misrepresentation as a seller. So these are all the little things that seem really simple, but you're not going to think of it. You're not going to think of it if this isn't something that you do day in and day out. If you don't have a team, the right team with you to guide you through this process. You can find that buyer, great. But again, you need that team to help you to manage and navigate through once you find that buyer to make sure that we have a nice, smooth transaction.
Yes, agree with you 1000%. Well, Erica, thank you so much for joining us today. I appreciate it so much. As you know, I love working with you. I always tell people, hey, let me get my pit bull. She'll know the answers and we can go from there. So thanks again for joining us on the show and have a wonderful day.
Absolutely. Thanks, Liz. It's been a pleasure.